erodes one of the core Woodhouse principles upon which ACC was founded, that of comprehensive cover. Hearing loss has only ever been covered by ACC if it has been caused by an accident, by the work environment of an employee or by medical treatment. A claimant doesn't get ACC cover if it's caused by a natural process or by disease or infection. But even if hearing loss is caused by an accident or by the work environment, this bill will deny ACC cover to someone who is only a little bit deaf due to that cause. And so in the Select Committee we heard from very many submitters saying that 6% is very much more than just a little bit deaf. So claimants with low-level hearing loss caused by industrial deafness will have to meet the cost of hearing aids and any other costs arising from it themselves, even if their overall hearing loss attributable to all causes is significant. This is like denying a person cover if one only has a small fracture or only minor ligament damage. Given the stocktake now underway, this has the potential to be the thin end of the wedge for removing cover for injuries that are considered minor. Going down this path, what's next? Who's next? Denying a person cover if you only have a small fracture. So the disentitlement provisions of this bill also erode this principle of comprehensive disentitlement. And so the Minister has made much of the disentitlement provisions in relation to criminals. And I sir, made the point in the Select Committee, and I make it again now, that in fact the disentitlement for this category of persons amounts to a double penalty. A person commits a crime, they're punished for their crime. The punishment is proportional to the crime that they commit. By denying that person cover from injury, rehabilitation and compensation, that person is effectively punished a second time, but punished in a way that is disproportionate to the crime that they have committed, whereas the repugnant to justice provision in the existing law actually deals with that perfectly adequately. And so I want to talk about the disentitlement resulting from intentional self-harm or suicide, because, sir, at the very core of accident compensation is this principle of no fault. And the punishment that this bill seeks to impose on the families and dependents of those who have harmed themselves at their own hand is, sir, a fundamental breach of that no-fault principle. I want to come now, sir, to this the principle of complete rehabilitation. I want to agree with ACC Futures Coalition that the existing vocational independence provisions are already a breach of the Woodhouse principle. But the provisions in this bill take that breach further. They rip it further apart. The bill removes the requirement that the vocational assessment of suitable work takes into account a claimant's earnings before his or her incapacity, and we've already heard about that in this debate. A claimant who is earning, say, $1,500 a week before his or her injury will have that weekly compensation stopped if he or she is found to be able to do some job for 30 hours a week that pays only the minimum wage. And this runs counter to the purpose of the Act, which is to rehabilitate injured claimants to the greatest extent possible. And it's an exercise, sir, in cost transfer. It transfers the cost of rehabilitation from the state, from ACC, onto work and income and to the injured person themselves and to their family. So it's a fundamental breach of yet another Woodhouse principle. I want to come now, sir, to the Woodhouse principle of real compensation, and in particular to the provisions of the bill in relation to holiday pay and to the erosion of cover in the bill for seasonal and casual workers. The bill will result in holiday pay paid on the termination of employment being treated as earnings for the purpose of abating weekly compensation. This proposal is both unfair and an erosion of workers' rights. Holiday pay accrues in respect of time when a worker subsequently injured has not yet sustained the injury.
Mr. Chairman.
I call the Minister.